The Right to Information Act 2005, or RTI, is one of the strongest tools Indian citizens have to demand accountability and fight corruption. But today, this pillar of democracy is facing new questions. And it's all because of the Digital Personal Data Protection Act, or DPDP Act. Let's understand the full picture. Why is this in the news? Recently, Union Minister Ashwini Vaishnav responded to a wave of criticism from opposition leaders and civil society activists. The criticism? That certain sections of the DPDP Act would make the RTI Act toothless. Congress leader Gaurav Gogoi called it draconian, stating that under the new law, citizens won't even be able to access information like which contractor built a bridge that later collapsed. Leaders like Rahul Gandhi, Akhilesh Yadav, and Priyanka Chaturvedi have all accused the government of pushing the RTI Act towards a road to ignorance. But what's really going on? Let's unpack it. What does the RTI Act do? The Right to Information Act came into force in October 2005. It gave every Indian citizen the legal right to request information from any public authority. The law was built on 4 key pillars: empowerment of citizens, transparency, accountability in governance, containing corruption. According to the law, all government bodies, central or state, are duty-bound to share information with the public unless it's sensitive to national security or individual privacy. To implement this, the Act created a 2-tier appeal mechanism: a Central Information Commission and State Information Commissions. The CIC, as per Section 12 of the RTI Act, includes the Chief Information Commissioner and up to 10 other information commissioners. Their job? To hear appeals and complaints when government offices deny or delay information. But what's the problem now? The problem lies in a provision of the new Digital Personal Data Protection Act. The DPDP Act proposes changes to Section 8(1)(j) of the RTI Act. Currently, this section protects personal information from being disclosed, unless it serves a larger public interest. But under the new DPDP law, that larger public interest clause is being removed. This means, even if the information relates to public corruption, if it involves personal data, it may no longer be disclosed even under RTI. That's why many are worried, because this change could shield wrongdoers from public scrutiny. What do RTI activists say? RTI activists, journalists, and digital rights groups have warned. This isn't just a technical change. It could create a blanket ban on revealing personal information, even when it's necessary for public accountability. Imagine this. A government contract gets awarded to a relative of a minister. You file an RTI to know the details. But now, you may be told, sorry, this is personal data. Do you see the problem? What does the government say? Union Minister Ashwini Vaishnav says the DPDP Act is not meant to destroy RTI. Instead, it is meant to protect the right to privacy, which was declared a fundamental right by the Supreme Court in 2017. Let's remember the K.S. Puttaswamy case, a landmark judgment. The court ruled that privacy is part of the right to life under Article 21. So yes, privacy is important, but so is transparency. And the challenge today is, how do we balance both values without weakening either? What's the ground reality? Even before this law, the RTI system was facing serious problems. According to a 2024 study by Satak Nagrik Sangrathan, 4 out of 29 state information commissions were defunct. 3 had no heads, 10 had a waiting time of over a year for hearings, and 19 commissions didn't even file their mandatory annual reports. Former CIC Yashovardhan Azad highlighted more issues: mounting backlogs, delays, casual handling by officers, and poor infrastructure. In short, RTI is already struggling, and the DPDP Act could make things even harder. What should aspirants remember? If you're preparing for UPSC, State PSCs, or law-based exams, here's what you must know. The RTI Act 2005 key features, structure, and its role in democracy. The DPDP Act 2023/24 provisions relating to personal data. The conflict between transparency and privacy. The K.S. Puttaswamy judgment, right to privacy as a fundamental right. Real-world implications on governance, journalism, and citizen rights. Final thoughts. The Right to Information Act was a revolutionary step towards empowering Indian citizens. It opened windows into the working of government machinery. The Digital Personal Data Protection Act aims to guard our personal information in a digital age. But the real question is, can both exist peacefully? Or will one end up silencing the other? That is the debate we must follow carefully. Because a strong democracy needs both transparency and privacy to thrive. Thank you for watching. Stay aware. Stay informed. And remember, awareness is the first step to empowerment.